have a number of cases here that deal with a range of issues, racial segregation, prayer in the public schools, a couple of privacy cases there that Griswold and Lawrence and Garner versus Texas. In any of the other cases really that were on that list that I didn't talk about just now, what they all have in common, one of the things that they have in common, in addition to the fact that at the time that the Supreme Court handed down its decision in those cases, whether it was 1896 in Plessy versus Ferguson or the early 1960s with the school prayer cases or the Texas Sodomy law in 2003, one of the things that they have in common is that in addition to the fact that they were quite controversial at the time that the court handed down its decision, and in some of those cases, the controversy still persists. I think I was telling you, kind of making that point when we were talking about the right to privacy earlier in the semester. I told you that Griswold versus Connecticut case, for example, resurfaces every time a president sets up a name as a nominee to the United States Supreme Court. The Senate Judiciary Panel that is going to make a recommendation on confirmation of the appointee, they'll ask them about the court's decision in Griswold. So a very controversial case, all of these. At the time, and in some instances even today, remain controversial. Okay? But beyond that, there's an aspect of the controversy that I want to explore a little bit with you for the rest of the class meeting and then into Wednesday's class meeting, and that is, it has to do with the role of the court itself. Right? There are some critics who argue that in these cases, the Supreme Court is overstepping. Please turn off your cell phone, it really distracts me. There is quite a bit of controversy over the role of the court, that the critics are saying that in these cases the court has overstepped its judicial authority and instead is acting as, in effect, a legislative body, substituting its wisdom for what is good policy for that of the elected representatives, whether those representatives are in Congress or whether they're in the state legislature or whether they're on the school board. Whatever the governing body is that's responsible for making these policy decisions, they're elected by the people of that district or that state or whatever the case is. And you have these 9 justices in Washington on the Supreme Court who have the nerve to substitute their view of what's good policy for that of the very people who were elected to do that. I want you to try to appreciate anyway, how that argument or how that debate cuts to the fundamental role that some people view that the court has in our system. Do you understand what I'm saying? That when the court handed down its decision in Brown versus the Board of Education, for example, not only was there a lot of debate, frenzied debate about racial integration, but there was also an underlying debate about this is not really a legitimate decision of the Supreme Court. The Supreme Court is not, the Supreme Court of the United States, these 9 justices who aren't elected by anyone and who serve life terms, they're not supposed to be stepping in and substituting their wisdom for what is good public policy for the Topeka Board of Education. Those are the people who are elected to make those decisions, the critics argue. Or in the New York public schools in the early 1960s, the argument might have been, who are these 9 justices in Washington to be substituting their view of the very people who were elected by the people of the state of New York to make this decision? Or in Texas, in Lawrence and Garner versus Texas, don't have to go back that far. If you go back and check newspaper accounts, for example, from 2003, when the Supreme Court handed down its decision that Lawrence and Garner versus Texas case, if you're willing to do a little bit of looking, look at the newspaper accounts, you're going to run across some articles where essentially critics are arguing, here's the Supreme Court, here they go again, substituting their vision for what's good policy for the elected representatives of the Texas state legislature. You understand what I'm saying? That is an aspect of the debate, setting aside the merits of the particular case that we're talking about. Is it a good thing or a bad thing to have a law that criminalizes homosexual sodomy? setting aside that debate altogether, we've got a more fundamental debate running through all of these cases where people are essentially debating the role of the court. And if you think this is just an academic exercise, something that only happens in a course like this, or an upper division course, or something like that, in a political science classroom, well, it's not. Every time we have a presidential election, for example, and presidential candidates are asked, they're always asked, while they're out on the campaign trail, what will be your approach to appointing justices to the Supreme Court? And some will argue, well, I'm going to, particularly Republican candidates for president have argued in recent years, well, I'm going to appoint justices who are restrainers. I remember Donald Trump did it, for example, in 2016. I remember George W. Bush very clearly making the case that when he had an opportunity to appoint justices to the Supreme Court, he was going to appoint restrainers. That's the term George W. Bush used, right? Restrainers, right? What does that mean? And the authors of the textbook introduce you to the concepts of judicial activism and judicial restraint. Yeah, those are concepts that are introduced in an academic context in a course like this, but they're also concepts that have some understanding in the broader political debate, the broader political discussion. What does George W. Bush mean, or what does Donald Trump mean when they say that they're going to appoint judges who are restrainers? I suppose Donald Trump means that he wants judges who aren't going to let him have his way on immigration policy. But he's not going to try to thwart his immigration reform efforts, as he's had some frustration with that with federal courts. Okay? But he may mean other things by it as well, in other areas of public policy. Well, as a political scientist, I will tell you that there are decisions of the United States Supreme Court that are tantamount to policy making. But certainly not every decision, and not even most decisions of the court qualify as policy-making decisions. But we have to have some criteria, objective criteria, for determining whether this decision of the Supreme Court is or is not an example of judicial policy-making. An objective set of criteria for determining whether this one is or is not. It can't just be a matter of whether we agree or disagree with the court on the merits of the decision. Because if you think about it, that debate that I'm describing to you, who are the critics? The critics who charge the court with policy making out there in the popular political debate, they're most likely to be the ones that what? Let's take a specific example. Let's go back to the 1950s in the debate over racial integration of the public schools. Who was most likely to argue in response to the court's decision of Brown versus the Board of Education? Oh, here goes the Supreme Court again, overstepping its authority and substituting its policy for that of the elected representatives. Who's most likely to make that argument? People who are trying to maintain a system of racially segregated schools, or people who want to racially integrate the schools? People who are trying to maintain the system of segregation. And in the school prayer cases, who's most likely to criticize the court for overstepping its authority and substitute people who support prayer in the public schools? What are people who are opposed to prayer in the public schools going to argue? They're not going to say, yeah, you're right, the court is making policy, but so what? They're going to say, the court's not making policy, the court is just upholding the Constitution. Right? And all these other areas that we're talking about. But what I'm telling you is, and this is what we deal with on Wednesday, okay, that we have to have a more objective set of criteria than just whether we agree or disagree. And so that's where we'll start on Wednesday.